Welcome back to the No Judgement Podcast. I'm your host, Wil Halaz, and today we are going to be diving into what happens when fire meets gasoline. That's right, we are talking about Sia's divorce. Her estranged husband, Daniel Bernard, has filed some pleadings with the court alleging that he needs emergency full custody based on some allegations regarding to drug abuse. So let's just kind of jump into it. This was a 2-year marriage. They had one child, a 1-year-old son. So at the beginning of this case, there were allegations that Mr. Bernard had, that he was under investigation for child pornography being on his computer. Now, since then, that investigation was ruled inconclusive and it is no longer going on. But under that, they entered into a consent order where Mr. Bernard was limited to what essentially amounts to supervised visitation. So somebody else had to be present during his visitation. Now, Mr. Bernard is making allegations that Sia concealed a 2-week hospitalization in LA where she allegedly tested positive for barbiturates and benzos. So, a couple of things here. First of all, custody. When there are allegations of misconduct, how does the court deal with those allegations, and what might be, an automatic path to supervised visitation versus what might be a concern for the court, but they're going to have to dig into a little deeper, all right? Clearly, when we're talking about offenses related to children, in this case, allegedly child pornography, again, it sounds like that he's been cleared of that allegation, and so, 2 thumbs way up on that. We don't want to, nobody likes to see those cases, but when there are offenses that are related to children, my state in particular, and I would assume most other states, are going to have statutes in place where the most that a parent could have is supervised visitation. And it's clearly for very good reason, right? We want to make sure that we're protecting children and that they are not going to be put in a situation because they are incredibly vulnerable. So in this one, it looks like the court kind of did the right thing, did what we would expect them to do, which is play it safe, make sure that we have supervised visitation until these allegations can be more fully vetted out. If there's a conviction, obviously, then it's an automatic. The maximum that somebody could get is supervised visitation. The court ultimately is going to determine whether or not that is appropriate, but the first thing they're going to do is say, we're not going to give you any more than supervised visitation. Now, we get on to these allegations of drug abuse, and also there were some allegations also about alcohol use, drinking to get drunk, that sort of thing. Maybe even hanging from a chandelier. Who knows? No, I don't think there were any specific allegations on that. But that being said, there were some allegations about drug abuse. Sia actually does admit that she is 6 months sober. So if we're, doing the math here, filed 7 months ago, she is 6 months sober. Clearly, this was something that was known in all likelihood during the relationship, but post-separation, it's being brought up as a concern. So, what does the court do with that? Well, the court has actually, in general, my experience has been that courts have come a long way from the initial gut reaction of somebody's got a drug or alcohol problem, they're going straight to supervised visitation, okay? Clearly, we want to protect children. We've already talked about that. That is the baseline standard, is protecting children. But the question is, if somebody is recovering from a drug or alcohol addiction, what should the court do with that? Well, what I have been seeing is that the court applauds the efforts to become sober, to maintain sobriety, whether that be from drugs or alcohol or any other sort of addiction, getting the help that you need. So here we've got this sort of catch-22 position that a lot of people feel like they're in, where it's, if I know I have an issue with drugs or alcohol, is it okay for me to go and address those issues through some sort of treatment? And the short answer is yes. I mean, at least it should be, in my opinion. But when you go and get that treatment, there's another question. Are those treatment records available for the other side to see? And if they are, or if they aren't, can the fact that that person went into treatment be sort of weaponized against them? This is sort of the thing where it's a never give up sort of situation. You have to obviously maintain that sobriety. And seeking additional resources to help you with that, I believe, is and should be applauded by the court. Obviously, we want to see success there, but the first step to success there is admitting that you have a problem and seeking the additional help. So, you may think, okay, drugs or alcohol, it's an unstoppable train. It's not going to be something that is going to allow me to have what I would call normal custody time with your child, but that's not the case. Seeking the treatment, kind of coming out alive on the other side is something that courts want to see. All right. So, in this one, couple of wild ones, couple of spicy allegations here going on. Interestingly, Sia did sort of, I won't say she said like, I forgive you, but she did say that she was open to Mr. Bernard having more expanded custody time. Now, she still wants there to be somebody who is an experienced caregiver. You can decide for yourselves what that means, but she is sort of, at least nominally, seeking to move forward together, for lack of a better term, and to kind of move through these things. But I see this as a good example of, those potential areas of misconduct that can be automatic with regard to the child pornography allegations versus something we've got to dig a little deeper into when we're talking about drugs and alcohol and overcoming addiction and things like that. So, we're still trying to figure this one out. Obviously, it's relatively early in the court process. Like I said, it's been going on for about 7 months, so we'll keep an eye on this one as well, see if anything new or exciting comes out of this one. But another thing to be, really aware of here is if you're at the beginning of this process, of the divorce process or a paternity process, and you have these types of issues in your case, it's really important, first of all, to talk to an attorney, okay? Get that advice. They're going to help you sort of map out where you're going forward, but also go and get that help. We talked about the shifting view of the court where there's not that immediate gut reaction of, hey, this person has had a problem in the past, so therefore they still have that problem. If you're going out, you're seeking treatment, you're doing the right things, that's something that the court is going to be aware of, and they're going to applaud. I mean, I think, again, every judge is different, but my experience has been that judges like to see you taking that proactive approach. And that's something that is good for you to work with your attorney on so that you're doing it in the right way. Like I said, those records may become available to the other party. So those are discussions you want to have with your attorney about what are the implications of me going and seeking this treatment. What are things that I can do to, put myself in a better position going forward, both personally and also strategically for my case. If you have this as an issue in your case and you need help, feel free to give us a call. Be happy to sit down, have a consultation with you and talk about some of your options. Again, if you like the content that we're providing you here, hit that like button, hit subscribe, and as always, no judgment here.